Yes.
Order in the court.
Mr. Ramos Amaya, you're charged with driving while intoxicated. You're facing up to a year in jail.
All right, folks, buckle up. Judge No Nonsense just entered the chat. When a judge says, "You're not going to like how I handle this," that's your cue to shut up and listen. This isn't Judge Judy Sass. These are real stakes, ankle monitor included. Let's see how Sandra handles the heat.
And/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
Yes,
Okay.
On October 28, 2024, the officer was dispatched to Hempstead Road in reference to a person down. Upon arrival, the officer met with a witness who advised that around 8:50 p.m., she observed the defendant's motor vehicle to be parked in a parking lot at Speedy's Fast Track and observed the defendant to be passed out.
It's a safe place to stop, very well
in the
lit.
driver's seat of the car. The witness also observed the vehicle running. The witness attempted to wake the defendant, but he was non-responsive. Upon the officer's arrival, they also observed the defendant to be unconscious behind the wheel of the car with the vehicle running. Upon getting the defendant to exit the vehicle, the officer observed a moderate odor of an alcoholic beverage, glossy eyes, slurred speech, and a swayed stance on the defendant's person. The defendant admitted to drinking. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 6 out of 8, 1.
2. Okay, pause. Did anyone else catch that jail time math not adding up? First, it's 10 days credited, then suddenly it's just 1. Either someone's got a fuzzy memory or someone's about to be really disappointed. And in court, time served isn't just a number, it's leverage.
And the defendant consented to breath. The results were .228 and .221.
So you just found him there in the parking lot?
It was reported as person down. There was a call that came in. He was unconscious.
What kind of evidence is there that he was driving at any time? How do we know that he was not just hanging out at Speedy's and drinking?
Well, you're right.
Crazy?
The officer found him unconscious behind the wheel with the vehicle still running at the time. And
I understand that. I understand, but maybe it was for warmth, so he could breathe. What evidence is there of driving? Do you have anyone that sees him driving? Do you have
the witness just sees him parked already with the vehicle running, and that's what.
I understand.
And that's what we have. Is the call came in.
Michael, do you have anything else? You know?
Judge, so we have defendant unconscious in the driver's seat of the vehicle, and the court's issue.
He's in a parking lot of Speedy's. If he's in the middle of the road, unconscious, that's something, right? If he's in the middle of nowhere, unconscious, and there's, he had to have gotten there somehow, okay. How do we know he wasn't inside Speedy's?
Well, Judge, my opinion is here.
3. Here comes the real concern. If you couldn't make it through probation the first time, why should we believe you'll do it now? This is a classic red flag in court. Past noncompliance puts everything else on shaky ground. The judge is playing chess, not checkers.
All we have to show is that probable cause is met in the case. He is unconscious in his driver's seat of the vehicle while it's on. That, in the state's opinion, is more than enough.
Driving while intoxicated. It's not sitting in a car while
Operating a motor vehicle.
What proof do you have of operation?
I can provide you, if the court needs case law citations of operation and what is considered enough for operation. If you give me like 5 minutes, I can get that for you.
No rush.
Thank you,
Really,
Judge.
we got until the end of docket. Show me something that says just sitting in a car,
Yes,
you
Judge.
know, with it on.
And it's not a public roadway either. It is, it's
It's a public place, Judge. There's multiple case law.
I get that, but my issue is, how do we know that he wasn't inside Speedy's just going nuts on alcohol and he just goes back in his car and just sitting in his car to sleep it off? I don't know that. We don't operate on hunches, right? That's what I'm saying. Like, if he's
assuming that the state is correct in their case law, it still doesn't address your essential question. I mean, let's just say what they're saying for operation purposes. It still doesn't address that at the time that the officer found him, he was at 0.08 or higher, or any operation at all while he was intoxicated.
I just want some proof of operation.
I can get you the case law. Yes, Judge.
I'm not asking much. All right, take a seat, Mr. Ramos. I'm not ready to rule yet. Just leave it at that, whatever it is. Yes. Hey, do you have scissors?
Can you send me the case, please? See how I can stick it. He says he has it. We can send it.
He's ready to go?
Right, so there's multiple.
Now we lost the interpreter.
Oh, okay.
Oh, sorry. Okay. What's this? Can you send me the?
So it's Anderson v. State.
Oh, can you send me the?
Yeah, I'll email it to you.
Anderson v. State, you say?
Yes, Judge.
What's the code?
I'm gonna send it to you right now. What is his client's name? His client's name is.
Listen to the judge's tone here. He's not buying what the prosecution's selling just yet. He wants more than assumptions. He wants someone to say, yes, I saw him drive. And honestly, that's a fair ask. Clip 5.
What's your client's name?
Ramos. Is that?
This is
It's the unpublished opinion?
Hold on.
maybe I'm looking at the wrong case. This is a sexual assault? No.
No, I think it's the 2010 case. George Anderson.
It's a 2016.
It's 2016.
What's
2016, you
I just
say?
sent it, yeah. I'm just trying to get the closest to what we have here in this case. There's multiple cases that,
Yeah, it's an unpublished opinion you're sending us.
sure, but the facts are very
Yeah,
similar.
but it's an
not-
unpublished opinion. Sir.
Okay, I mean, I can, if you want to give me more time, I can get more case law, but I mean, this is just something that I found in 2 minutes that is very similar.
Take your time.
Okay.
There's really, there's
Just
so much
email
we
me and I'll
have
come back.
until.
Got it.
No,
So give me some time, I'll shoot you an email.
there's just no rush. And then
Okay.
too, Herman, if you find something.
Yeah. Okay. Approach on Ramos again. I don't know if you've taken a look at the cases that the state provided. They're very distinguishable, both of them. On one, the Prego case, someone actually sees the driver driving at some point, and then.
I've read about 17 different cases.
Right, and then the second one that the state has provided, the driver self-admits that they were driving at some point, and in both cases, they have the seatbelt on, and there's other evidence of driving and operation, which is distinguishable. In this case, there's no facts that he had a seatbelt on, or he was seen by anyone driving, or he ever admits to driving. So their reliance on those cases are unfounded because it doesn't fit this fact pattern that we have before us today.
So Judge, the first case that I'll refer you to is Prego versus State, which in that case.
Do you email it to me by chance?
I can send you an email right now, Judge.
That's the one the person is seen at some point.
Can I make my argument, Counselor?
No, I thought you were emailing, yes.
I am, but let me
while
at
you're
least make
emailing,
my argument.
I wanted to give a synopsis of the case.
Let me make my synopsis, and then I promise you I'll let you respond.
I was in back reading. I must have read like 17 cases. God, I don't think that there was any case that supported your position. You know, I must have gone through at least 17 different
Well, they have to
cases,
prove
you know?
it's a totality of circumstances. Just behind the wheel is not sufficient. They have to provide. Okay.
So let's go to Kenneth versus State, Judge. I sent you an email. Did you receive it?
Okay.
Okay. So in that case, I'm reading just word for word from the case. Courts interpret, quote, operation of a motor vehicle very broadly, and they cite Prego versus State, which is an appellate case. They cite Smith versus State, which is an appellate case. And they say, quote, while driving does not involve operation, operation does not necessarily involve driving. So we have to prove operation of a motor vehicle. Operation does not necessarily mean driving. It states any action that is more than mere preparation towards operating a motor vehicle falls under the definition of operating. So in this case, we have
Does the fact that you turned the keys onto the car,
is enough, Judge.
That's his opinion. There's no case law that
That's
says
what the
that.
case law literally
You're saying
states.
mere
word
preparation.
for
like
word.
conspiracy, right?
Yes.
Law
Or
of conspiracy
law
is, it has to be more, like.
So
an
what did he
overt-
do other than start the vehicle? There's nothing more that there's nothing more than mere preparation. It
And
was a
that's
hot
what-
day, and the Prego case, people see him, they have the seatbelt on, which is more than mere preparation. They don't show the seatbelt on. In the other case, the Houston case, it self-admits that they were driving. In this case,
Yeah, I mean, that's right. We're not gonna, if there's a self-admission, that's.
right, and those
now
are
we're-
what they relied on. The two cases, on the second case that he's quoting, or he showed you on the site, that person, that defendant self-admitted, and there was also other evidence
Have you
beyond
found-
mere preparation.
You found any case law to support the position, though?
Well, what position? It's their burden that there was more than mere preparation.
No, but I've asked you to see if you, because I went in back and I literally read through 20 cases
Yes,
and I can't find any case that supports the proposition that that's not operating.
well, what they have to show is more than mere preparation. Having your vehicle on by itself is not beyond mere preparation. That is just mere preparation. They have to show either they had a seatbelt on, or the car was in neutral, or something beyond.
This is where it gets legal nerdy. The state's dropping case law like a hot mixtape, arguing that even turning the key can count as operating a vehicle. Think about that. You don't even have to move an inch to be considered behind the wheel legally.
Legislatures tell us
Clip
if you feel like you should just stop and pull over, and that's what he did. And then someone comes at a later time.
There by your admission.
No, I'm not, because if you stop, turn off your car, and then you get hot because you're in a hot vehicle, turn it on, that's not operation. That is not beyond mere preparation.
Where are you getting that from? How are you saying that's not operation? What is your citation for that?
You just stated in your case law that you have to prove more than mere preparation.
Okay.
My
Love
statement is, all you have shown is mere preparation. That's it.
But
You haven't gone beyond mere
but to
preparation.
be clear, you don't have any legal basis for your opinion.
Yes, your opinion is right there when you said it's a totality of circumstances and you have to show more than mere preparation.
And I think the fact that.
There is no case law that says that.
Find me something.
Well,
different.
that case says it. That case says just turning on your vehicle, you have to show more than mere preparation.
That's not what it says. It doesn't
You
say
read
just
that.
turning on your vehicle is not enough. That's not what it says.
Is that Prego?
This is Kennett versus State.
And then that case is also
I'm
distinguishable.
going to read it exactly what I read to you just a couple of minutes ago, Judge.
Okay.
Courts interpret operating a motor vehicle very broadly, and they cite multiple cases. While driving does not involve operation, operation does not necessarily involve driving, stating that any action that is more than mere preparation towards operating a vehicle falls under the definition of operating. So, any action that is more than mere preparation towards operating a vehicle. That does not state that doing this with a key and turning on the car is not more than mere preparation. Our position is that that is more than mere preparation. You've put the key in your car. You've activated your vehicle. That is more than mere preparation. You're attempting to operate the motor vehicle. You don't need to be seen.
This final exchange is a chess match. The defense is basically saying, sure, he turned on the car, but that's not enough. No gear shift, no seatbelt, no movement, just the AC. The judge isn't swayed by vibes. He wants
Driving
case
the
law,
vehicle
something
to satisfy
solid to back it up.
operation under this case.
I want to be clear. I'm not saying that it has to be seen, but they're stating exactly conversely what I'm saying. You're asking me to show you where just putting on the key is not operation. Well, I'm asking for them to prove just putting on the key is mere preparation, because they're stating a case where the defendant admitted to driving, okay, in that case. And that is in the facts of the case. And that's what the court relied on, that in addition to this law, that he admitted to
You're
driving.
saying in Kennett,
Yes, that
Admitted
defendant
operation?
took the stand and admitted that at some point she operated the vehicle. In the Prego case, someone saw that person driving the vehicle. Then they saw him at a later time
They admitted to driving at an earlier time.
Yes.
They didn't
yes.
admit to driving then.
Yes, that's correct.
Can you point to me to at least one case that shows me where they have found it not to be operating?
No, but I'm also going to state this to the court. Can they show you one case where just having the key in the ignition is more than mere preparation? They haven't shown you that.
I went through 17 to 20 cases, Herman. I haven't found, I looked.
Either way, I bet. Either way, either way. So it's up to the
I
court's
didn't find
discretion.
any, yeah, I didn't find anything to support the position.
Theirs or mine.
So let's do this. I'm going to find it for now.
Okay.
Go back, do some research.
No, there isn't. I'm very clear on the law. They have to show more than mere preparation. And they have.